You with me?
It's ready.
All set?
All set.
Okay. All right, welcome everyone. In just a few minutes, I'll be introducing Dr. Kelly, who will be presenting this morning on navigating the confusing world of school discipline. So I want to welcome everyone to the first educational advocacy webinar of 2018. We will be continuing to present these on a monthly basis. And we really am very, very grateful for Dr. Kelly for her participation and for continuing these amazing webinars. The response has been incredible. With that said, I want to reach out to everyone to let us know if there are particular topics you would like to hear, because this is about you, obviously helping you with your advocacy. So we want to make sure we are covering the topics that you need. So send us a quick email. At the very end of the PowerPoint, the email will be posted where you can give us your thoughts and your ideas on topics you would like us to cover in the coming year. That would be great. For today's topic, we have uploaded the PowerPoint. It's over there under handouts on your control panel. You'll be able to print that out and keep that as a resource. The other thing I just want to cover quickly, questions. You do have the ability to send us questions during the presentation. Hopefully there will be time for Q&A at the end of the PowerPoint, in which we will try to get to as many questions as possible. If your question does not get answered during the presentation or during the Q&A, please use that same email, edu.advocacy@gal.fl.gov. It will be posted at the end of the PowerPoint to send us those questions. That way I can forward them to Dr. Kelly, who has been super great about responding to everyone who sends us questions via email. So that really is the best way to handle it and make sure that your questions will get answered. So with that said, we're right at noon. Dr. Kelly, are you ready?
I'm ready.
Okay, welcome. Happy New Year.
Hey, Happy New Year, everybody. Hope you have a great 18. I want to thank you all for joining us today. We're excited to do this with you guys. You guys are tremendous in what you do for these kids, and you are appreciated by people all over the state. I can tell you that. Okay, let's start. Discipline. Navigating the confusing world of school discipline. Hold on. Well, it's not forwarding. We're having a technical difficulty here. Oops. Well, it moved. Disclaimer, this training is to be used as educational material and is not to be considered legal advice. They make us give that disclaimer every time. What exactly is discipline? When I talk about discipline, what am I talking about? School discipline is a required set of actions by a school district toward a student or group of students after the student's behavior disrupts the ongoing educational activity or it breaks a pre-established rule created by the school system. That means if a kid breaks a rule, what happens? It is based on each district's code of conduct. The code of conducts can be found on every district's website. They contain specific information about the infractions and the possible consequences, and there should be language relative to students with disabilities. Now, I suggest you guys, depending on what district you work in, I suggest you go to their website and you look for the code of conduct. You can download it and keep it on your computer. You can keep a copy. Just know how to reference it. If you help a student, if one of your students were to get in trouble, the code of conduct is very important at that time. So we're going to talk about today discipline. Discipline means in legal terms, discipline refers to suspensions and expulsions. Discipline is not necessarily, just a reprimand, an informal reprimand. I think everyone knows how to handle that. Or even an in-school suspension of a class or two if a student has done something wrong. Those things aren't problematic, and I think most people know how to handle that. You talk to the student, find out what went on. That's the end of it. When you get up to the level of suspensions and expulsion, that's when you need some technical information. So why do suspensions typically occur in a school? Well, some kids with disabilities have inappropriate behaviors that are caused by their disability. The behaviors may make it difficult for them to learn, cause harm to the child or others, or isolate a child from his peers. So, the things that lead to these suspensions are often disability related, and so that's what we're going to focus on today. Suspension in general. Most code of conduct manuals allow for students to be suspended for up to 10 days for a conduct violation. For students with disabilities, kids having an IEP or a 504 plan. Now remember, we've done trainings on those. If you're unfamiliar with 504 or with IEP, please visit the website and go back through those webinars. You would do yourself a world of good. Kids with disabilities typically have either an IEP plan or a 504 plan. For students who do have one of those two things, the student is entitled to a meeting called a manifestation determination if the student has been suspended for 10 days or the student has been subject to a series of suspensions of a similar nature totaling 10 days in one school year. So this is kind of an interesting concept. What Congress decided when they made the federal laws covering students with disabilities, Congress decided that, we were not going to exclude kids with disabilities, especially based on manifestations of that disability. So what Congress intended by this rule was that the school not just perpetually suspend kids over and over and over, but that they stop and they look at what's going wrong. What can we do to help keep this kid in school? So what they decided was if there's a pattern of suspensions, if the kid is suspended for 3 days and then 2 days and then 3 days and then 2 days, that's 10 days. You need to have a manifestation determination meeting to discuss what is going wrong. I'm going to tell you about some suspension terms. A suspension is sometimes called a removal or a unilateral change of placement. Removal is obvious, but what is a unilateral change of placement? Well, because the school can unilaterally, without asking for input from anybody, change the student's placement from his regular setting to either a new setting, an alternative center, or home. And what this means is the kid will engage in a behavior that violates the code of conduct. If it's a kid with a disability, the school will have a manifestation determination. If it is found that it is not a manifestation of his disability, the school can unilaterally, on their own, move the child into an alternative setting or can send them home to be educated at home, homeschooled. If the student does not have a disability, they can actually send the student home for the rest of the school year without services. So suspensions can end up being a very serious thing. So again, this unilateral change in placement, when they kick them out to an alternative learning center, they can put them in these alternative learning centers, and you may see this in the school districts you work in, where a kid will get a 10-day suspension or an 8-day suspension. The districts will move them over to the alternative school for that period of time until they have a manifestation meeting or until they have a meeting to get the child back in school. For 11 or more school days, if you go over the 10, they can move them into an alternative learning placement, an alternative school. And that usually happens if the child has committed a very serious offense, and they'll say, okay, he's gone for the rest of the school year. We recently had a client who was sent to an alternative learning center for 2 years based on conduct. They can only do this, though. They can only send them out for more than 10 days if the behavior is not a manifestation of their disability. And we're going to talk more about that because I know it's confusing. They can send people to alternative placements for 45 days or less for the use of weapons, drugs, or infliction of serious bodily injury. We will talk a little bit more about that in a minute. And this is for students with disabilities. For kids without disabilities, they may permanently bar them from the school, moving them to an alternative placement. So I'm going to go back through that quickly. The way schools use these alternative placements, these unilateral placements, is if the student is suspended for up to 10 days, they will ask the student to serve those 10 days in an alternative school. They could just send them home for 10 days. That is often the case. If the student is suspended for more than 10 days, and then they will go to the alternative placement typically. They need to have a manifestation determination before they do that, and they need to decide that the student, that their behavior was not a manifestation of their disability. And I know that's confusing, so we're going to talk a little bit more about that later. And then they can send a kid for 45 days or less for weapons, drugs, or infliction of serious bodily injury. 45 days is the limit for those things for kids with disabilities. Kids without disabilities can be sent or exiled forever. Now, I've talked about this manifestation determination meeting. So what is it? Well, it occurs after this pattern we're talking about, or a block of suspension days of, this is totaling more than 10 days in a school year. It's actually 10 days in a school year. Sometimes that can be 10 days. You'll have a student who does something crazy and they get a 10-day suspension. But most often you will have students who get these like piddly suspensions as it goes along, a day, a day, a day, a day. And I would like to just pro tip here is if your student is in-school suspension, those still count toward the manifestation determination meeting. We've represented kids who have been in in-school suspension for 30 days and the school didn't have a manifestation determination meeting. So the practice just continued. So once you get to this 10-day mark, you have to have this meeting and you have to determine if this behavior is caused by the disability. I always, if possible, advocate that it is, because then the student gets to remain in the building. Here's another pro tip. If you can get a copy of the DSM-5, and there are pages in that show the symptoms of each disorder. And a lot of kids with ADHD, you can pull that list of symptoms and take it to the school meeting and say, look, this is part of the disability. This is disability-related behavior, what he did. He lacked the impulse control to not do that. Same thing goes for students you have with oppositional defiant disorder. That's very common among kids in care. Kids with trauma in their past, and again, we've talked. I am a believer that once a student is in care, they have suffered some form of trauma. Being removed from your family, no matter how terrible your family situation, is traumatizing. If you think back to yourself, what it would have felt like to be removed from your home, I think you would feel it was traumatizing. So you can bring part of the DSM-5 or any online materials about the reaction to trauma and the symptoms of trauma. And you can make that argument that, look, this behavior is related to this kid's disability. Once you're in the meeting, there are two questions that have to be answered by the IEP team or the 504 team. And the two questions are, is the conduct caused by or have a direct and substantial relationship to the child's disability? And we just covered that. You know, we would believe most of the time it is related to that, and we would try to print things from the internet or DSM or whatever you have, a diagnosis that you may have related to that child, and bring to the meeting and say, yes, this conduct was caused by this. We got that. So the second question that needs to be answered is, if the conduct was the conduct the direct result of the school district's failure to implement the IEP? Now, I'll be honest with you. I have not been to very many meetings where the school district is willing to say, yeah, you know, we just messed that up. We didn't follow that IEP. But this is what you can do. If the student has a behavior plan, you can ask if everyone involved followed the behavior plan. Chances are, no, they did not. So that is an avenue to pursue. So these manifestation determinations meetings, they may result in a revision of the IEP, a new functional behavioral analysis, and a functional behavioral analysis for people who have missed previous trainings are you have a behavior person come in and do observations of the students, determine why they're engaging in that behavior, and how best to help them stop that behavior. So it's a formal thing. It's considered an evaluation, and you have to have signed consent to have a functional behavioral analysis. But it is something that if you get to this manifestation determination, you would need to talk about. You can ask for a new one. If your student doesn't have a behavior plan, then you definitely need to ask for an FBA. It's called an FBA. You definitely need to ask for an FBA to find out what the heck is going on that this student is engaging in this behavior. Manifestation determination meeting, it's a place that you can make a new behavior plan or talk about a new placement. Now, I'm not talking about an alternative school. We've talked about that. Sometimes schools can send a kid out to an alternative school on their own. This is for students with an IEP or a 504 plan. There are safeguards in place that the student is allowed to keep his same placement if his behavior is a manifestation of his disability. But that may not be the best thing for the student. So the placement generally remains the same unless the IEP team agrees that another placement more appropriately serves the student's needs. Sometimes I'll look to the need to put the student in a behavior room or an autism room. Maybe they need more direct service in behavior. And so that's the time to discuss that at this manifestation determination meeting. In ESE, special ed, children are safeguarded from disciplinary exclusions that would deny them FAPE. Now remember back to our previous trainings, FAPE is a free and appropriate education. Now what that means, because that's a lot of words, what that means is the student is still entitled to the same quality of education that they would have had they not been suspended. And so if they are suspended for long periods of time, over 10 days, then all of the educational services on the IEP would need to continue at home or in an alternative setting. So if the behavior is a manifestation, you get to this meeting, everybody talks, everybody says, yeah, obviously what he did was related to his disability, his ADHD, his defiant disorder, his rage disorder. Then again, we talk about the FBA can be conducted, but the behavior plan should always be either implemented if there wasn't one, or it should be modified if there was one because it's not working. A student with a behavior plan who is subject to 10 days of suspension that behavior plan's not working. So ask that the behavior plan be revised. Ask that more data be collected. And if they need to, ask that they do another FBA, a functional behavioral assessment. You have the right to do that when you advocate. And if it is a manifestation of his disability, again, the child returns to the current placement unless the parent or school disagree. So now what happens if they say the behavior isn't a manifestation of his disability? Like, you go in, you make your arguments, look, this is this kid's disability related behavior, you know, you can't expel him for that or exclude him for that. Oh my goodness. And they look at you and go, huh, well, we think it's not a manifestation, and we want to, you know, discipline him in a way that nobody likes, like that you as an advocate don't like. Well, at that point, if the district says, if this IEP team meeting or 504 team meeting, if they decide it's not a manifestation, then that student will be disciplined in the same manner and for the same duration as with children without disabilities. And although educational services, the IEP services are still required for kids with disabilities, they are not required for students without disabilities. I once represented a young man in 3rd grade who was expelled out of a school without any services for the rest of the school year. Turned out, not shockingly, the student was a student with a disability, and the district had not recognized that. The student had 45 days of suspension. He had, I think, I don't know, close to 100 ISS class periods, in-school suspension class periods. So this is probably the time to tell you, if you have a student who has not been identified as a student with a disability, and this student is getting these multiple suspensions, someone needs to ask for an evaluation for that student, a psychological or school psych evaluation. Because chances are pretty good, if you've got the combination of a kid in care and a kid who is being kicked out of school regularly, that there's a problem. It may be a mental health problem. It may be a behavioral disorder problem. It may be a learning disability problem that the child's unable to deal with, and so they act goofy rather than just say they don't know. But whatever's going on, we need to get to the bottom of it, and we need an evaluation for that student. So, zero tolerance. Now, you know, we've talked about the protections for the kids with disabilities. They're entitled to this manifestation determination, and if the behavior is a manifestation of their disability, they're entitled to stay in the school and life goes on. But that's not always the case. There is one very important exemption to that rule, and it is for zero tolerance infractions. And students who engage in behaviors related to the following may be sent to an ALC, an alternative learning center, or home despite disability determination. And the three are, we call it the Holy Trinity: weapons, drugs, and significant bodily harm. Now, weapons and drugs, you understand that. That is, you know, a blade longer than, I think it's 4 inches in the state of Florida. You can look it up statutorily. They will say that a pencil is a weapon. You know, no, really it's not. But, you know, weapon is usually, the cases I've had, it's where a student has maybe a hunting rifle in the trunk of the car that they forgot, or they have a knife in their, you know, pocket because they were afraid of being jumped at school, or they had been bullied and, you know, they felt the need to protect themselves. That's weapons. That's pretty clear. Drugs, that's pretty clear. Typically it involves selling their own drugs to peers or buying drugs. But what does serious bodily injury mean? I mean, that sounds terrible. Well, serious bodily injury means a bodily injury that involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or mental faculty. I once took a student case. I went to due process court because they had removed the student to an alternative learning center for serious bodily injury. And basically on the courthouse steps, the other attorneys realized that they could not meet the standard of serious bodily injury. He had kicked someone and he had bitten someone else. And, you know, that does not rise to the level of moving a student out of a general education setting or their placement. It literally has to be that you've disfigured someone. So schools typically are getting smarter and they don't use that to remove students. Sometimes, and I still hear this, districts will say, well, we moved them to the alternative learning center because he's dangerous. Well, you can't do that. I think we did this. So what is dangerous? To send a student with disabilities to an alternative school due to a concern of dangerousness, the fear that the child will commit a violent act, the school has to either get an agreement from the parent or the guardian, go to due process, which is educational court, or they need to get an injunction in federal court. You cannot remove students because they might do something. What you can do is put students in a more supportive environment if you think that they're going to become unstable, but you can't just kick them out. So what if a kid isn't yet eligible for IDEA or Section 504 for an IEP, special ed? What if they're not eligible yet, but they get into trouble all the time? Well, if the school district has knowledge that the child had a disability before the behavior occurred, these IDEA protections apply. And what that means is this. I'll give you an example. Schools will have a kid, they call him a high flyer, you know, he's always, you know, in everyone's radar. He's getting suspended a lot, constantly in trouble. Mom may have said, hey, you know, he's got ADHD, I'm really sorry, you know, he can't control himself. The school should be aware, they're on notice that that is a student with a disability. You'll find in teachers' notes, in conference notes in those files that the teacher is saying, oh my gosh, you know, I think this kid needs extra help, there's maybe something wrong with this student. Any of those things should alert the school that this is a child with a disability, and therefore the federal protections of IDEA and 504 apply. So what is needed to show specifically that a school did have knowledge or should have had knowledge that a student might be a student with a disability? Now, I'm talking about these kids of yours that are constantly getting in trouble, or getting in trouble rarely, but when they do, it's really significant. What, you know, kind of triggers the school that now they're aware they need to know? Well, either someone expressed the concern in writing, someone had requested an evaluation in the past, the teacher or other school personnel expressed specific concerns about a pattern of behavior demonstrated by the child, and they sent that concern to the ESE department, the special education department, or so they're the things that the law says gives them a basis of knowledge, it's called. But there is considered to be no knowledge if the parent or caretaker didn't allow an evaluation or has refused services, or the child was evaluated and found not eligible. So if you're in a case where somebody has said, no, we don't want that student evaluated, if the kid was evaluated and found eligible for services and people denied the services, or if the student was evaluated and found not eligible, then the argument can be made by the district that they didn't know. I would still make the argument you knew. It rose to the level once before of an evaluation and, you know, the provision of services. You did know, and I would move forward that way. So what happens if the school really didn't know that this may be a kid with a disability? you look through the file, you don't see any notice, you don't see any reason that the school should have known this was a kid with a disability, you need to request an initial evaluation at that point during the disciplinary period. So the example would be they've kicked your student out to an alternative learning center for, say, 45 days or for the rest of the school year. They've kicked him out. You show up, you look at the file, and you say, no, I don't think this is right. I think this is a kid who might have a disability-related behavior problem. Either this kid has been through trauma and he's reacting to authority inappropriately, which we see all the time, or he's got ADHD and it had been undiagnosed, or whatever you think. Request that initial evaluation during the disciplinary period. If you request an evaluation during that placement in an alternative school, they have to speed it up. They have to do it quicker than 60 days. That would be the time for you to get the student to his pediatrician if he hasn't had a diagnosis, and to see if the student maybe does have ADHD or some other disorder like ADHD comorbid with oppositional defiant disorder, or intermittent mood disorder, or any of the things we commonly see among kids in care. So, how do these kids end up with multiple suspensions? It's not just that the kid is doing something. There's a system problem too that allows this to happen. Sometimes kids, after they've been suspended once or twice, they become kind of a target for school officials, right? They recognize them more easily. They kind of can catch them being bad a little bit more easily than a typical kid. So what is the system thing that happens that allows schools to suspend and expel these kids at will? Well, the first thing that happens is there's a lot of discretionary language in the Code of Conduct, letting the administrators make arbitrary decisions. If you look through these Code of Conducts, or I should say when you look through these Code of Conducts, you will see that most every part of the discipline section says the principal the principal shall be responsible for. So everything gets to fall in the lap of the principal and not, or the principal designee, and not in the lap of the IEP team, which would be more appropriate for a kid with a disability. No provisions are made for students with disabilities in many counties, and so they have this Code of Conduct, but there really is very little language that says, students with disabilities who are being disciplined, there should be the inclusion of a special education professional, or these should be done through an IEP team decision. Districts are getting better about that, and we have worked with districts to include that language, but typically most school districts do not have any provisions for kids with disabilities. And finally, there are no clear definitions of these violations. When you look through the Code of Conduct, you're going to see, it'll say disruption, fighting, defiance. Well, these are all very loosey-goosey terms. And we have found that disruption is something very different depending on the school you're in. In some schools, disruption is being loud in a hallway. In other schools, disruption is when you're, screaming at the top of your lungs in the cafeteria and you're inciting violence. So there's a wide range of that. Fighting in some districts is if you shove another student out of the way. In other districts, it only means mutual combat. And then defiance. What is defiance? I think all of us would struggle to put a definition to the term defiance that would, be adequate. So I've talked about these alternative schools, and I don't know if you're familiar with them or not. I don't know if you have students in them or not. Typically, they are schools. Sometimes they're in strip malls in some counties. Sometimes they're separate standalone schools in separate facilities. It depends on where you are, but they're very different. They look very different than a traditional school. They are often dumping grounds for unidentified or underserviced students with disabilities. We have filed claims on behalf of students in alternative schools. Our experience is that kids in alternative schools typically read at a level far, far lower than typical peers, which to us signals that these are kids with unidentified learning disabilities who probably should be helped in a different way. While these kids are in these alternative schools, the IEP and the 504 plan is still in effect. You need to advocate to make sure that all supports and services are still being provided while they are in these alternative schools. You're still supposed to have IEP meetings. If he gets speech language therapy or she gets occupational therapy, those need to be provided while at that school. And what I would suggest is that you advocate for increased supports. Call an IEP meeting or a 504 meeting or a school meeting and just ask for increased support for these students. Obviously, the student was struggling in the last place. So what are we going to do to help this student here? And what are we going to do to help that transition back into general education when it happens? And while you are there and while you are advocating in alternative schools, please ask to see the work product of the student and the copies of the curriculum from the student's classes. We have found that many times these kids are not doing the same work that their typical peers are doing, that they're doing, baby work. Kids in high school are being given, 5th grade reading material because that's what most of that alternative center class reads at in the high school. So be very careful and feel free to advocate that you want your student on track academically, that you should not lose a year or 45 days of quality education simply because they are in an alternative school. So let's talk about what do you do? You're advocating for this student and the student's gotten a suspension. Oh my gosh, what do we do now? Well, if it's a 1-day suspension, if it's a 3-day suspension, even if it's maybe a 5-day suspension, I would ask for the paperwork. I would try to parse out what happened, perhaps talk to the school administrator, see if, everything's working all right. But if you get up into the 6, 7, 8, 9, 10-day suspensions, I would call an IEP meeting, a 504 meeting, or a regular school meeting. And I would just say, listen, we need to talk. This isn't working, and we need to see what we can do to help the student. They're the things you can do up until that 10-day suspension or that school removal. But once you get that 10-day suspension that ends up in a school removal to an alternative school, you have the right to challenge it. You have the right to challenge that move and that 10-day suspension. And so it's an appeal process. Usually it's a hearing before a group of school board members. I have never found them to be successful. We don't typically go with clients to those meetings. But what you can do as an advocate is you can try to avoid that appeal process. And you can focus on the IEP process instead. And so while you're at that manifestation determination meeting, for this pattern of suspensions or one really big suspension, while you're at that meeting, if they say that this behavior is not a manifestation of the student's disability, right? Or you show up after a meeting where it's already been done and they've determined that it's not a manifestation of the student's disability and they're going to put them in an alternative school, that is a time to put your detective hat on. Ask for a do-over of the manifestation determination meeting. You can do that. Your goal is to, through this IEP or 504 process or through another school meeting, gather evidence that either the district was aware of the disability and ignored it, you know, when they made the determination to move him out of the school, or maybe the school didn't get the whole picture. And that may be a time to ask for things like incident reports from the school, prior incident reports. Go through your file, see if there's any information in your file that says the student has a disability. Sometimes that information does not get given to the school. Kids in care are often diagnosed with behavioral, mental disorders, other areas of concern very early. And somehow that does not get transmitted to the school. So you can ask for a meeting before the student is moved and say, hey, listen, I think we've got new information to consider. Can we get together to consider this information to keep this kid in a mainstream school as opposed to the alternative learning center? If he's already at the alternative learning center, you can have that IEP meeting or that school meeting, the same thing, and say, I would like a do-over. Let's talk about this. Let's see how quickly we can get him back to the general ed with some supports. Now, remember, you have the power to impact the educational outcomes of the kids you advocate for, meaning you may be your student's last best chance to stay in school. For that reason, I always say it, go forth and be bold. Questions? There you go. And I'll turn it back over to Patty and see if we've got any questions today.
We do have questions, Dr. Kelly. And everybody, please take note of the email address that's on the screen right now, because that's where you can send questions after the end of today's presentation, or anytime, actually, if a question pops up that you need assistance on. So please make use of that. I check it on a daily basis, and I forward questions on to Dr. Kelly that I'm not able to answer, which is likely about 99% of them. So.
And I wanted to say at this point that every advocate feels the same way. This is the most difficult topic that we teach. It is putsy. It's not easy to explain because of the terms they use, although you need to be familiar with the terms because the school will use them. And so if you have any questions, please do reach out. And even if they're basic, if it's something that's, a little too lengthy to do in an email, I will be glad to call you and talk you through the process when I get a minute. Okay, so don't be embarrassed by the questions. This is confusing and difficult.
Absolutely. And anybody who selected clicked on the hand raising, we need you to actually type the question to us. That would be really helpful. Okay, let's get started so we can get through the questions. Can a school avoid the rules about 10 days by not suspending the child, but by putting the student in a disciplinary room all day?
The disciplinary room is considered an in-school suspension. It's considered an exclusion under the law, so no, they can't. This is the deal. That language comes from exclusion, comes from the Office for Civil Rights, who says that you cannot exclude people with disabilities any more than you could, hide all the people with wheelchairs over in a separate room. So yeah, it's an exclusion, and you need to remind the school it's an exclusion, and it goes toward the days of suspension. Now,
okay.
It may not go directly toward the 10, but you still need to have that conversation and that conference that they can't get out from under the 10 by hiding them in there.
Okay, great. Next, can we bring in Southern Legal Services for legal representation of the student?
That would be between you, your coordinator, and anyone else who's involved in that process. I know that we are court appointed at times over here at Community Legal Services in the counties we work in. If the guardian advocate and coordinator and the guardian attorney feel that they have a situation that is difficult, they will reach out to me and ask would I be willing to be court appointed, and I usually say yes. And then they write the order for the court appointment for us. So that's the process, but obviously you have to speak to the grown-ups in the program about it.
Okay. Concerning days in alternate placement, does a child sent home at noon for 1 day suspension have 2 days towards the 10 days or 1 day?
If they send the kid home at noon and he's gotten like half a day in, that would probably be a half-day suspension. You know, so consider that a half-day suspension. If they send him home at noon, what they can't do is send him home at noon and say that he's got suspension the next day and not count that half day. The other dynamic I need to talk to you guys about is when you start, you know, kind of tickling them about the suspension numbers, what they'll do is they will call the guardian and ask the guardian to pick the student up. They'll say, now he's not suspended, but he needs to go today. They're not allowed to do that. That's illegal. So what whoever is in charge needs to say, the guardian needs to say, is he being suspended? And if he is not being suspended, then he needs to stay. And I'm not afraid of suspensions. You know, parents, I think, are afraid of suspensions sometimes. Suspensions are data that a program is not working and that the student needs more support and is entitled to more support. So for me, if you're going to kick them out, it needs to come with a suspension. Okay?
Okay. Do code of conducts vary from school district to school district?
They do indeed.
Okay. So each one adopts their own?
Yeah, they adopt their own. Now, the school policy and procedure manuals that are found on the Florida Department of Education website, those are typically pretty much the same. But the code of conduct can vary. There's a lot of similar language, but they're very different. If you look at Broward's School of like Code of Conduct, and then look at, say, I don't know, another one, they'll be different. Broward's is very different because it includes disability language. You know, it's just done a little bit better. So yeah, they are different.
Okay. Do these rules apply for children in the GED program as opposed to the mainstream, I'd say, in addition to the mainstream regular school system?
Okay, well, that would depend on where the GED program is. If the GED program, if the student is under 18 or under, 22 or under if they have a disability. If the GED program is part of the regular public school, then yes, it would. But typically, these are standalone programs. The question I would ask is whether the GED program accepted federal funds. If the GED program accepts federal funds, if it's paid for by the school district, then yes, these rules apply.
Okay. Does being in foster care count as a disability?
Nope. Nope.
Okay.
No.
That's a simple answer. Okay. Yeah. High school students end the day by 2 p.m. So would anything after 12 be considered half day?
You know, it's considered 2 hours of suspension. You know, that is probably close to 1/3 of a school day. No, you know, if it's once, I wouldn't sweat it. But what you'll see happening is that teacher, whoever that student has at 2 o'clock or, you know, 1:45, whatever, that teacher may be engaging in a pattern of exclusion where that teacher just doesn't know what to do with that student. And so the teacher kicks the student out of class at that time each day. So again, I would have a school meeting and just say, you know, if it becomes a pattern, and say, what the heck's going on in that class? Can we get a different teacher? Can we, you know, provide some support to the teacher? Can we have the teacher be trained? You know, or do we need an evaluation for the student to see what's going on if they don't have an IEP or a 504 plan?
Okay. How do you request an evaluation for an IEP or 504 for a student who has already been in an alternative program for over a year?
Oh, yikes. very easy to do. Very, very easy to do. And I would, suggest that you go back through our previous webinars when, try to make the time, because I think that's important that you understand this whole process. And so do the IEP one, do the 504 one, and the evaluation one. But the answer to your question directly is you ask for an evaluation in all suspected areas of disability, and you put that in writing. And if it's not in writing, it didn't happen. And typically and it has to be the person with signatory rights over the student. So it may be the foster parent, it may be someone court appointed, if whoever has the right to sign the documents, it may be the parent still, has to make the request. But you as a team member, we've worked with parents many, many times, and just said, we think this is a good thing for your student, for your child, and we think we need an evaluation where you sign consent. And that's how you do it. But the request needs to be in writing. I would email it actually to the principal of the school and the head of exceptional student education. And the reason I like email is because then you always have a copy that you asked.
Okay. How does the No Child Left Behind law work with Florida regulations regarding retention if curriculum is not completed?
Well, No Child Left Behind became ESSA, and so the Every Student Succeeds Act. I don't think I understand the question, Patty. Can you read it again?
Yeah, hold on. I get back to it. I scrolled on to the next one. That's okay. Okay, how does the No Child Left Behind law work with Florida regulations regarding retention if curriculum is not completed? We might just have to ask the sender of that question.
Yeah, I think that person needs to send an email, and I can, call the person and talk that question through.
Okay.
More specifically what they're asking.
Well, if she's not on, I've got her name, and we'll get her contact information.
Perfect.
Okay. I know some questions are hard to make it really concise, and
yeah.
Okay, no problem. I have a grandson that has disciplinary issues due to abuse and domestic violence with his mother. He now lives with his father and had issues when he started school. The school was made aware of this and they have been working with him. Does this give proper notice, or does he need something from a doctor?
Notice is funny, right? Like as we saw in the webinar, notice has to be given to an administrator. It has to be from a teacher to an administrator. It's very putsy how that needs to be done. I would definitely take a diagnosis to the school and ask if the student doesn't have any kind of help yet. Ask for an evaluation, obviously, because you want to get on this sooner rather than later on the support that the school can give. And if that person, wants to reach out through email to me, I'd be willing to talk them through that a little bit more.
Okay, great. If a single parent or both parents are working, how is home suspension dealt with?
They don't care. The district does not care. That is on the parent to provide some kind of support. Typically, I've had clients quit jobs to stay home. Have the student move in with a relative. It's a very draconian response to send a kid home because it's the highest form of segregation. If a student is sent home, someone needs to have the conversation about why the student can't be in an alternative learning center, because home is really a black hole for these kids. Typically when they're home, they just get in more trouble. You know, they go out, they run the street, the parent is responsible for the education, even though the school does provide off-campus instruction in the home. It's typically only for 4 hours, 2 to 4 hours a week, and the parent is responsible for the rest of the curriculum. They'll put them on online instruction and not give them any in-home help, and the parent is responsible. And I don't know if any of y'all have ever tried to get your kids to do homework, but, you know, being responsible for an entire high school curriculum for a student who's struggling, it ain't easy. And so these kids actually end up coming out of off-campus home instruction with no credits, typically.
Okay. All right, next, if a child is sent to an alternative school pending an evaluation or service, for example, anger management, whose responsibility is it to initiate the service? The parent, the sending school, the alternative school?
The evaluation, does that mean, okay, so that had a lot of moving parts for me in it. So let's just kind of parse it out. So if a student is sent to an alternative school pending an evaluation, you know, meaning, okay, they sent the student to an alternative school, but they agree that the student may have a disability, they're going to do the evaluation. The school is responsible for doing the evaluation in a timely manner. Since a student is in an alternative school, it has to be expedited. It can't be the 60 days that the kid languishes there. They've got to speed it up. And as far as the anger management, it would depend on what the agreement between the district and the parent was, whether the school should provide that or whether they ask the parent to provide that. In my world over here, you know, although I would suggest that the parent get the student counseling or therapy if there's an anger problem, I would ask that the school provide the anger management, because this is a school-based issue, and so school is responsible for those services at that point, especially if we suspect this is a student with a disability. So I'm not sure that answered your question, but if it didn't, send an email.
Okay. Sorry, I have to kind of scroll through some of these because it's some were questions we already answered of the technology nature. Okay, if student with disabilities is suspended and educational services must still be provided, what does that include?
It includes everything on the IEP. And so if that student is getting an hour a week of speech language therapy, then they need to still receive that through homebound instruction or over at the Alternative Learning Center. Anything like speech, language, occupational therapy, physical therapy, any of those things. If the student has a specific reading instruction program that's in the IEP, that needs to be in place no matter where the student goes. If they get social skills training on the IEP, that needs to be in place. If they're at the alternative school and they have a 504 plan with accommodations and they get extra time or they get breaks, those need to be in place at the alternative school as well.
Okay. If the child was sent home without a suspension notice, what can the guardian ad litem do?
You know, it's a teachable moment, and so I would suggest contacting the school and just having a conversation about why they were sent home and did it rise to the level of a suspension. And what they will probably hear is, oh yeah, we were trying to do him a favor and not suspend him. And that may be fine if it's once. If it's once, that may be fine. But if it happens more than twice in a school year, then it's no longer fine. They need to document that they're excluding him. And so just have that kind of respectful conversation with the school that, you know, not sure what happened, but, you know, we don't want to get into a pattern of sending him home. It just teaches him that if he's bad, he can go home. So let's figure out what to do. Maybe we can do instead. So that would be my suggestion.
Okay, lots of questions. This is great. Everybody's really
love questions.
Thinking.
Okay.
Okay. All right, we'll keep going here for a little while longer. If the student is already in an alternative learning center and you want to get a do-over, where does that occur? The old school or the alternative school?
It doesn't matter. They'll probably want to have it at the alternative school. And again, that is for situations where, they said it was not a manifestation of his disability and they're going to kick him out. And in those situations where you have information that would indicate that it was a manifestation of his disability, that would be when you would do that do-over.
Okay. Here we have a former school teacher. In the state where I taught, IEP conferences were held in the fall and again in the spring. What is the requirement in Florida?
Well, welcome to Florida. We call this, people who have practiced in other areas. I worked in Minnesota for 20 years as an educator. We call this the Wild West down here. It is whenever the student's IEP is due. And so we'll have kids who, they have their IEP start date is in August, and kids, their IEP start date is in May, and then all through the school year. So it is 1 year from the start date on the IEP is when you have to have that meeting. Now, parent or guardian, whoever stands in place, has the right to have an IEP meeting whenever they have a concern. And so I have had up to 14 meetings in a 6-month period for a student that had a kid in dependency who had significant concerns. So you're not stuck with that 1 year date. You can and should be having those. My goodness, you can and should be having those whenever you feel that there's a problem.
Okay. Let me try to get through some more of these. They're asking, there's two different questions. One is asking, is ADHD considered a disability, and is dyslexia considered a disability?
Yes to both. ADHD typically is found on an IEP. On a 504 plan, they just say it's ADHD. On an IEP, it's typically under the designation of other health impaired. If you remember back to our former trainings, there are only 13 designations under IDEA to get an IEP. And so ADHD isn't one of them. So that goes in under other health impaired. And dyslexia goes in under specific learning disorder, because that is a learning disorder, not a behavioral disorder.
Okay. Is a child eligible for a 504 plan if, because of a previous family situation, he has not attended school for over a year?
Oh my goodness. No, but if a student had not attended school for a year, and during that year the student was subject to a whole lot of, upsetting things, which may be possible, then I would ask for an evaluation of that student. A 504 plan, and again, I encourage you guys to please go back and look at these other webinars, because they all kind of start at the beginning, they all kind of tie together as building blocks to where we are now. A 504 plan is given to students who have a disability that impacts a significant function in their lives. And so what that means is if the student is having trouble reading, concentrating, thinking, following along, dressing themselves, for kids with mobility issues, then they are entitled to a 504 plan. And you call a meeting with the school and you ask for a 504 plan, you review the documents, and that's how you do that.
Okay. Just two more, and I think then we're going to have to call it quits. And I'll remind everybody what they can do if they still have a question. Is sitting in the principal's office all day the same as a suspension?
I don't know why people do this. Okay, again, it's an exclusion, not a suspension. And that's the language you have to use. Under Section 504 of the law, now just little reminder, there's 2 laws that cover kids with disabilities, Section 504 and IDEA. And under Section 504, being separated from your typical peers is an exclusion. And so I would say if the student has a disability, it's definitely an exclusion. If the student does not have a disability, then I would say it's time to get that student evaluated because something's going on. I don't think the principal just has that kind of time that, he wants to hang out with the student. That's my answer.
Okay. And just finally, a list of accommodations for kids with disabilities. Is there something available that actually lists the various accommodations that can be?
The Florida Department of Education website has a booklet of accommodations and appropriate accommodations. It used to be tremendous. It used to have about 1,000, accommodations in it. Now it's pretty narrow. But if you go to, if you just Google FDOE accommodation guide, it'll come up. You'll find it. And accommodations are anything that allows the student to have access to his educational program. So again, remember, let's reflect the difference between a 504 plan and an IEP is IEP, the student needs specialized instruction. A 504 plan, the student needs accommodations to access his education. And so it's typically things like extended time, breaks, a scribe, a reader, peer note. It can be a ton of things. Being allowed to drink water, having an electronic device on the bus, having snack on the bus. It could be whatever they need. It doesn't involve a change in the curriculum or extra teaching.
Okay. All right. I know a couple people made comments about the use of acronyms. Apologize for that. We speak in acronyms a lot and we forget. So maybe we'll put together a list of educational acronyms and get that out to everybody and try to be more careful of that in our presentations, that we spell out what we're talking about, or at least initially.
With the new terms, I try to always include them. And so if you're seeing terms like IEP, 504, and you're not sure what they are, then again, I would just ask, and we can certainly do that, but I would just ask that you go back to the previous trainings and get those building blocks that kind of lead to this, because this is an advanced topic. Discipline is an advanced topic. And so, which is very difficult to navigate unless you understand the basic IEP 504 process. This is incredibly difficult without those. So I would encourage everyone to go back. I think one's a half an hour and one's 40 minutes maybe, and go back through and view those, and that would make it a lot easier. Patty, also too, we have a list of acronyms that we can to you that probably should be on the website, and people should be aware, maybe they could have those while we go through this in case they've missed something.
We could upload that as on our next webinar so people can print it out, and we can also, I'm sure, post it on our website as well. Or if you send it to me and anybody wants one, reach out to me at edu.advocacy@gal.fl.gov. and I'll send it to you. And that's the same as the PowerPoint. If you have any difficulty printing that out, just let me know and we'll get you a copy of that. So we want to make sure everybody has the resources they need. So just a reminder again, if you have a topic you'd like to have us covered, please send that to me at that same email, and I will share those with Dr. Kelly for our upcoming presentations, which will continue to occur on a monthly basis. So check your emails and your spam and everything by the end of the next maybe 2 weeks from now, because we'll be sending out the notice for our February webinar. So thank you, Dr. Kelly, so much for your time again.
No problem. My pleasure.
Thank you, everybody, for participating and hanging in there with us. We didn't lose too many people during. course of the presentation. If we did not answer your question, because I think there's a few that we didn't quite get to, please resend. That way I have your email and we can get back in touch with you with an answer. Okay, so everybody have a great rest of the week, and we'll be in touch.
All right, take care, everybody. See you next time.
Yeah, thank you.